as you see him as a criminal. But no, he's not. He's an accused person. He must enjoy the presumption of innocence. So when you see someone being brought like this in court, you have an impression that here is a villain in court. We don't want that. We want your lordship to see him as all other accused that you see here. So that on its own does not need some head of correctional service. He is before your lordship, that you can do. Does not need us to go to any other court. Literally, your lordship, with utmost respect, can say that this creates a bad perception to the accused person, that there is accused person that are seen as criminals, there is accused person that are seen as accused in a true sense. So that is part and parcel of what is going to be the motivation why no any other court but this one must hear this application. But because, my lord, administratively we had challenges that we could only serve this application yesterday at 3. What that means is that inevitably, even if your lordship wanted to hear this application, it's practically impossible, because we raise serious issues, legal points that need to be ventilated. And that's why in the service of the application we omitted a notice of application or a notice of motion, deliberately, in a sense that there was no one that would have been able to come here. But as a matter of courtesy and to avoid ambush, serve the affidavit. And we say that in our notice of application, we were going to obviously seek directives. If we had had enough opportunity to deal with this application, we would have prescribed the time frame, because there's no rule in this particular court that says that this one must file the application after 10 days, not Rule 612. That's not how criminal proceedings are conducted. Try to fashion or find the best possible solution under the circumstances to protect the right of the accused. We don't become the slave of the rules that are not applicable. So we would have prescribed and motivate why we prescribe as such.